Greetings and welcome to Judgements, Valid, Void, and Voidable from American Jurisprudence. This will be a continuation of where we left off on the last one on judgments. So let's get right down to it. So we left off on section 22, the effect of consent of parties on court's jurisdiction to render judgment. And before we begin, I just want to remind everyone this broadcast is strictly for entertainment educational purposes, not to be construed or used for any of your personal, professional, lawful, legal, financial, or tax purposes, so don't do this at home. Let's proceed. And before we do, actually, let's check with the chat. Yes, as Captain Jack has noted here, jur is a Latin word that means law or right, and as the maxim goes, law is the rule of right. So that being said, the quality of being prudent, cautiousness. We need to exercise prudence in such important matters. So exactly, this is really to scrutinize the rules of right and principles of law that really establish the quality of American common law. And this is at the root of it right here. So thanks for that, Captain Jack. Once again, Section 22, effect of consent of parties on court's jurisdiction to render judgment. So consent of parties, the effect of that. A judgment rendered in a case in which the court does not have subject matter jurisdiction is not validated by the consent of the parties purporting to give the court jurisdiction. Subject matter jurisdiction is a power that exists by operation of law only and cannot be conferred upon any court by consent or waiver. So subject matter jurisdiction is a power that exists by operation of law only and cannot be conferred upon the court by consent or waiver. Jurisdiction of the subject matter does not mean simply jurisdiction of the particular case then occupying the attention of the court, but jurisdiction of the class of cases to which that particular case belongs. It is the sine qua of, the sine qua non to a valid judgment. It may not be waived by consent of the parties. However, the consent of a person generally is sufficient to confer personal jurisdiction over that person. So the power of personal jurisdiction can come from consent of a person, but not subject matter jurisdiction. Nice. Let's see, going back to Porter versus Porter in 1966. As a subject matter jurisdiction, we saw Section 20 in the previous episode, and a few other cases there. And as a jurisdiction of the parties, that's what we were ending with in the last episode. We're on to Section 23, the court's authority to render judgment. Okay, so a lot of them wants us to define sine qua non. All right, so let's do it, especially with my terrible Latin. It'll help us get better enunciation. So that means we're over to Black's Law Dictionary. So just to remind everyone, we're going to look up, I hope it's in here. Well, here we got to get the pronunciation guide. This would be a good start, considering I have such terrible pronunciation of my Latin. KT, welcome. So I guess this is, unless anyone out there has better Latin pronunciation than I do, let's get to it here. Where we go? There we go. Here. We got to zoom in a bit here on this one here. Again, this is the scanned image, so it's a little bit different. So the sign S as in sanction, it's the INE, crime, whereas in risk or intent. I'm not sure here. A is in fact, qua, plat. Is that true? Well, I'm not too sure about this. This is kind of a strange pronunciation guide. I think that's just for the actual symbols they use, but not for the Latin pronunciations. Let's proceed here. S is going to be way down in here. Public duty doctrine, rule that a governmental entity cannot be held liable for an individual plaintiff's injury resulting from a governmental officer or employee's breach of duty owed to the general public rather than the individual plaintiff. The public duty doctrine, 1976 from Torts. That's an interesting one to look up. Serendipitous for it to be stalled here while it's there. There it is. Now it's catching up. It takes a while here with this scanned document here. It's an image. One very large image. So in the meantime, let's look at the chat here and see if there's any other comments here. Pronunciation, yeah, well, I wish I could read your mind. I'd probably be able to pronounce it better. And welcome to everyone else here. And let's get right back to the blacks. We're on stockbroker. Okay, so we passed it. Let's see, sign. Boy, this is... Here we go. All right, we're getting close. Okay, sign. Signee. P. Signee qua non. Qua non. Signee qua non. Or sine qua non. Without which not. So let's see which pronunciation flows from the tongue more easily. Is that sine qua non, or sine qua non? So sine qua non. I'm not sure about the sine. Or sine qua non. Any verdict here in the chat of which one we like better? I'm going to go with the second one here. I think the sine qua non sounds a little bit better because I'm not sure about saying that quay in there. Quay sounds kind of off kilter a bit. So we'll go with the sine. The sine, it looks like sine qua non, without which not. From the 17th century, an indispensable condition or thing, something on which something else necessarily depends. So it's a conditio sine qua non. And I believe you could also call this a consubstantiality. So this is a good term. I need to practice saying it better. Sine qua non. Sine qua non. Without which not. An indispensable condition or thing. All right, so we got that down. Thank you for recommending that diversion and everyone to stick with me through it. Well, now we can say the word. Let's get back to it. All right, in addition to subject matter, we're on the court's authority to render judgment. So in addition to subject matter and personal jurisdiction, there's a third type of jurisdiction which involves the authority of a court in a particular case. A court may not render a judgment which transcends the limits of its authority. A judgment may be properly rendered against a party only if the court has authority to adjudicate the type of controversy involved in the action. And give me a second here. I just realized I didn't have the chat refreshed here. So Sherry here has asked, what happens when a judge breaks and disregards the law and rules for the plaintiff? Well, that becomes another issue for the court and the rest of the or the jury to decide. I guess you'd have to make an objection would be the first thing. So it's noted on the record. If it's noted on the record, then he can address it properly. And audit them likes the sine qua non. Right. Well, you can have the have it however you like. I like the or that's he liked the sine qua non. All right. Either way, we got it down. That's going to be a little too hard for me to keep saying. Hopefully, we're not going to be speaking much Latin in this one or Greek, and we'll get back to the English and legalese. So once again, a judgment may be properly rendered against a party only if the court has authority to adjudicate the type of controversy involved in the action. So judgment can only be properly rendered against a party. Notice the terms here, against a party, not for a party. That's interesting. It doesn't even mention here, but I guess you can't have one without the other, right? A judgment is void if it is beyond the powers granted to the court by the law of its organization, even where the court has jurisdiction over the parties and the subject matter. Although there is authority, that lack of jurisdiction over the particular case merely renders the judgment voidable in certain circumstances. Thus, a judgment may be void if the court, although having jurisdiction over the parties and subject matter, enter a decree not within the powers granted to it by law. So let's break this down a bit here. I think what they're trying to get at here is the fact that even though they're only mentioned a court may not render judgment which transcends a judgment may be properly rendered against a party only if, and they're not mentioning for because again here we would be talking about a subject matter jurisdiction in this example here, and if a party consents to it, that still doesn't grant the court subject matter jurisdiction, and against it would be this case here, footnote 5, which is Dubai Petroleum Company versus Kazi, Texas in 2000, citing restatement second, judgments in section 11. Interesting. So, a judgment is void if it is beyond the powers granted to the court by the law of its organization, the organization of the court, even where the court has jurisdiction over the parties and subject matter. Although there is authority, that lack of jurisdiction over the particular case merely renders the judgment voidable in certain circumstances. So it's void if it's beyond the powers granted, but some jurisdictions it could be just voidable. Thus, a judgment may be void if the court, although having jurisdiction over the parties and subject matter, entered a decree. And remember, a decree would be in a equity or a court of equity or a chancery case, not within the powers granted to it by law. All right, let's move along. And now we're going to get into where we finally say, well, what are these voidable, void judgments, valid? Now, this is what American jurisprudence likes to do, is provoke your curiosity and then lay out the details. And before we get to that, let's check the chat. And here we get a good laugh from Captain Jack. Let's proceed. Let me refresh this, make sure we're all good. And we are. We're on to voidable judgments. Erroneous judgments. A voidable judgment is a judgment entered erroneously by a court having jurisdiction. Okay, so voidable is in a court having jurisdiction. And that seems all jurisdictions there. The term voidable denotes an action in which the judgment nonetheless operates to accomplish the results sought to be accomplished until the flaw is judicially ascertained and declared. So a judgment nonetheless operates to accomplish the results sought to be accomplished until the flaw is judicially ascertained and declared. Thus, a judgment is not void. A judgment which is voidable is capable of confirmation or ratification, and until superseded, reversed, or vacated, It is binding and enforceable. Wow. So here's our observation here. This is interesting here. A void judgment is so defective that it is deemed never to have had legal force and effect. In contrast, a voidable judgment is a judgment that has been entered based upon some error in procedure that allows a party to have the judgment vacated. But the judgment has legal force and effect unless and until it is vacated. Has legal force and effect. Interesting here. So what happens to the is there any kind of stay in force? Unavoidable, it seems not, but a void judgment is so defective that is deemed never to have had legal force. So remember, we're not talking about errors of law. These are procedural and legal errors, and we're only talking about legal aspects, legal force. That's our observation. In general, a judgment is void or invalid only where the trial court lacked jurisdiction or the judgment was rendered without due process of law. A judgment is not void or invalid merely because it is erroneous. So here's a big detail right here to pay attention to. In general, a judgment is void or invalid, so this seems synonymous, void or invalid, only where the trial court lacked two things. Either they lacked jurisdiction, or the other thing is the judgment was rendered without due process of law. Judgment is not void or invalid merely because it is erroneous. Erroneous judgments, which have been issued by a court with jurisdiction, are subject to reversal on timely direct appeal. Interesting here. So erroneous judgments, which have been issued by a court with jurisdiction, are subject to reversal on timely direct appeal. A court's action contrary to a statute or statutory equivalent means the action is erroneous or voidable, not that it is void. So statutes and statutories, or statutory equivalent, I should say, statute or a statutory equivalent means the action is erroneous or voidable and not that it is void, and thus is subject to ordinary, appellate, or other direct procedures to correct it. A party seeking to set aside a voidable judgment or order must act to set aside the order or judgment before the matter becomes final. There is a distinction between void and erroneous, as used with reference to acts from a judicial body. The general rule being that where the body has jurisdiction of the subject matter and of the person affected, its judgment in the case will not be void, though it may be erroneous. If the judgment is merely erroneous, it can be attacked and the error corrected only by appeal or by a direct proceeding to set it aside. While if it be absolutely void, it is a nullity from the beginning and may be treated as such without further proceedings to have such nullity judicially declared. Wow, this is powerful here, right here it is a long section, but this is about voidable judgments, and it gives us our contrast and our distinction here between void or invalid, void or voidable judgments. The distinction between void and erroneous, which would be, of course, erroneous or the voidable, as used with reference to acts from a judicial body. The general rule being that the body has jurisdiction of the subject matter and of the person. So if they have full jurisdiction, and the judgment will not be void, though it may be erroneous. So if it's in with the power of the court, as we read before, and the subject matter and the personal jurisdiction, right, is within the court, then the judgment will not be void. The errors can only have it voidable, meaning that, of course, the full force of the force of the law, the legal force would be in effect until it's somehow addressed. So, practice tip here. These are the best things with American jurisprudence. The distinction between void and voidable judgments is critical when the time for a direct attack has expired. Before then, the distinction is less significant because whether the judgment is void or voidable, the result is the same. The judgment is vacated. So this is nice to know. The distinction is critical when the time for direct attack has expired. Remember, direct attack is for the appeal. Before then, before the time has expired for appeal, the distinction is less significant because whether the judgment is void or voidable, the result is the same. The judgment is vacated. So good thing to know. So was there a footnote for the practice tip? Was footnote 12, and that comes from this one here, 2016. So that's why they're giving us this practice tip, is to let us see current holdings, not necessarily being this is an operational law, but this is a current or in operation type of ruling that's looked to. So again, it's critical when the time for direct attack has expired. When there's no more time for appeal, now it's the most important. But regardless, if it's found to be void or voidable, the judgment is vacated. If it's found in favor of that, I guess you'd say. Okay, so these are just some more case holdings, more footnotes. And now we're on straight up void judgments. And before we get here, let's double check on the chat. Judgment in violation, well, that's where due process is one of the criteria, and that would go to the Constitution, the due process clause. Judges also have discretion. They do what they want for their budget. Yeah, well, some may say. If you're never served, then there would be no personal jurisdiction, if that is indeed true. And yeah, there would be an affidavit of service if you were served. All right. Indeed. Yeah, there would be affidavit of service. That should be on the record. Remember, everything operates by that record. All right. So now we're on to void judgments. Now we're on to the ones that operate. A judgment is void where it appears that the trial court did not have subject matter jurisdiction, jurisdiction over the parties, capacity to act as a court, or jurisdiction to render the particular judgment at issue. Thus, a judgment is entered without jurisdiction is void and can be vacated. A judgment can be void not only for lack of jurisdiction, but also where the court acts in a manner contrary to due process. A void judgment is one that has defect apparent on its face. Whether a judgment is void is a question of law, as Voidable we read earlier was about legal force and legal process and procedure. A judgment issued by a trial court without jurisdiction is a nullity. Without jurisdiction, there is no authority to give judgment, and a judgment so entered is without force or effect. A void judgment is one that, from its inception, is a complete nullity and is without legal effect. It binds no one and is not entitled to any respect. If it is determined that a judgment is void, it is as though such proceedings had never occurred. The judgment is a mere nullity, and the parties are in the same position as if there had been no judgment. A void judgment is in legal effect no judgment. No rights that are acquired or divested by it. It neither binds nor bars anyone, and all proceedings founded upon it are worthless. Wow. On the other hand, a judgment is not void simply because it is erroneous. A void judgment must be distinguished from one which is merely erroneous, as where there is an error in the exercise of jurisdiction. Generally, so long as a court has jurisdiction over subject matter and a party, The procedural defect occurring before the entry of judgment does not render a judgment void. A judgment based on an erroneous order determining jurisdiction is not void, but rather voidable. So a judgment based on an erroneous order determining jurisdiction. So there's your question about personal jurisdiction being served. So a judgment based on an erroneous order determining jurisdiction is not void, but rather voidable, it seems. So that's footnote 18. Wright versus Lewis, 2004 in Florida, 4th District Court of Appeals. Okay, so that's in Florida. I wonder what case that was. Okay. Jeez. All right, on to our observation here. Whether a judgment is void or voidable generally depends on whether the court rendering the judgment has jurisdiction. Generally depends on whether they have jurisdiction. So are we hammering this in? I think everybody here so far should have a clear distinction between void and voidable and the effects of both. It is not necessary to take any steps to have a void judgment reversed or vacated. The court has an inherent power to vacate a void judgment because such an order simply recognizes the fact that the judgment was always a nullity. A judgment absolutely void may be attacked anywhere, directly or collaterally, whenever it presents itself, either by parties or strangers. It is simply a nullity and can be neither a basis nor evidence of any right whatever. Such a judgment is open to attack or impeachment in any proceeding, direct or collateral, and at any time. To say that a judgment is void, or in other words, that it was entered without jurisdiction, is to say the judgment may be challenged in perpetuity. Because a court's power to vacate a void judgment is inherent, there is no deadline for it to exercise that power. That means you could have a void judgment vacated at any time. There's no limitation on time. In perpetuity, it may be challenged. Under the federal rules of civil procedure, the court may relieve a party or its legal representative from a final judgment, order, or proceeding on motion and upon such terms as are just, where the judgment is void. So we have here a judgment which is determinative of a claim arising in an action in which necessary parties have not been joined is null and void. A judgment is void when the court has no jurisdiction to issue it. Other defects merely render the judgment voidable. And that's Peacock versus Wave Tech Pools in Texas, 2003. As to due process of law, we saw this one in the previous episode. This one too, status of record. Remember, the record is very important in any kind of proceedings. As erroneous or voidable judgments. All right. Now, if there's any more elaboration on the footnotes, let's proceed on to section 26, validation of void judgments. This sounds strange. Not sure who's rogue. The no contract hoe may be rogue. And we have here, let's see. Oh, here we go. I'm sorry. Let me refresh this here one more time. There we go. Give me a second here and let's look at this. It was, oh, well, way up here. Great. Oh yes, it's a privilege to be able to share with you and have everyone along board with this to get on with this information. See, I just got railroaded in court this week. I challenged subject matter and personal, and the court just ignored it like I never challenged. I objected off the bat, and that attorney. Hang on a second, guys. Let me read it from here. That attorney comments all hearsay. Yeah. Oh, there's no plaintiff. Um, yeah, I guess it's case dismissed for lack of. Geez, there's no. What's the cause? Is there a show? You need to show a cause. The plaintiff has to be the one to do the show of cause. Otherwise, who's going to do it? To the judge? That seems strange. If judges read this and followed through with it, yeah, but you got to remember, you're talking about the not the brightest students from law school, anyways. There's an old saying in law school: the A students, when they graduate, they end up working for the B students, and the C students end up being judges. Yeah, well, I mean, they're in a club. It's probably worse than a club. They're running ads on your page. Shouldn't you be monetized? I don't know. I'm not fighting anymore. I'm just, yeah. By the way, I'm just happy we're not being too shadow banned, so we could just take what we got here. See, I'm not fighting anymore. I'm having the IRS and these guys, Secret Service. Yeah, well, good luck with that. But yeah, there's a lot of other remedies for us and ways of redress our grievances, and I think the courts are an undervalued resource that if we were just to learn a little bit more, I think we'd be empowered to exercise some of these latent rights and abilities that people have, because this force goes both ways. All right, let's continue here. We're on to the validation of void judgments. Seems strange and not intuitive. So, the general rule is that a judgment which is void cannot be cured by subsequent proceedings. So no more proceedings. Remember, on the face, it should be immediate, and everything is as if it never happened, which is void. Unlike fine wine, void judgments do not improve with age. They are void ad initio, void for all time. A void judgment cannot be brought back to life. Thus, a judgment that is void when entered is not retroactively validated where a party enters a subsequent general appearance, but instead remains void. Likewise, because a judgment entered by default without personal jurisdiction over a defendant who has not appeared is void. Wait a second. A judgment entered by default without personal jurisdiction, like if a plaintiff didn't show up, over a defendant who is over a defendant who has not appeared is void. A default judgment entered without personal jurisdiction cannot be deemed valid if the defendant filed an untimely responsive pleading asserting that defense. Okay. All right, just seeing if that one would apply to the previous question, but it didn't. But let's continue because there's a lot more. So validation of a void judgment is something that, unlike fine wine, the void judgments do not improve with age. So void judgment cannot be brought back to life. So it can't be cured with subsequent proceedings. Validation of it as otherwise. Here it seems that, yeah. Okay, we're on to Estoppel pertaining to invalid judgment. So this is a good one coming up here. Let's check onto the chat. Give me a moment here, open this up here. There we go. All right, it's all on record here. It says here with coffee. Foreclosure, it's all on record. My paperwork was my court. No rebutting or any affidavits or evidence by alleged mysterious. Okay. So in something like this, yeah, it's quite odd. I would say that you'd probably be when you're making your objections and such and you're getting it onto the record, you need to make it very clear about that your rights are not being observed and make it clear to be put on the record such so you'd have your you remember the power of the record that we talked about earlier. So you'd have something to refer to for appeal that would be material. So is one you file a motion for void judgment order and expect judge? No. This would be something where you'd have to present your facts and argue the fact that it would have to be. So you'd have to give your principles of law, in other words, to avoid a judgment, and you'd have to show errors of process for a voidable judgment, and then why you'd have to take action to vacate that judgment. So for a voidable judgment, it would be a two-step at least process, and for a void judgment, it would be prima facie, on its face. It'd have to be void because of principles of law or due process violation, lack of jurisdiction, it seems. Again, nothing legal lawful advice here, just my opinion from what we've read so far. And the visionary says, once you enter Article 1 under administrative law. Yes, but remember one other thing, though. Anytime we enter in the courts, we are in a governmental situation one way or another. And our First Amendment rights don't end there. They can't be given away. And remember, there's certain elements of this where they can't be conferred or denied or waived. So let's continue on here. I appreciate the feedback there. We're on to Section 27, Estoppel pertaining to invalid judgment. Now this is getting to our void judgments here, invalid judgments, or avoidable that's found to be invalid. The circumstances of a particular case may be such as to estop a person from setting up the invalidity of a judgment. Wow, a party cannot be heard to impeach a judgment which has procured to be entered in its own favor. And one who accepts and retains the fruits of a judgment is estopped from denying its validity. One who accepts the benefits of a judgment should also be precluded from questioning the validity of the burden imposed by an express condition on which the judgment was granted. In an estoppel by judgment, a party who accepts the benefits of a judgment, decree, or judicial order is estopped to deny the validity or propriety thereof, or any part thereof on any grounds. Nor can he reject its burdensome consequences. Wow. However, the mere failure to act with respect to a void judgment does not estop a person from asserting a right to property purportedly affected thereby. Mere failure to act with respect to a void judgment does not stop a person from asserting a right to property purportedly affected thereby. So this seems like a complex situation which would apply to these cases that we're seeing in the footnotes here. And of course, there's nothing more to elaborate. So this is where you would not accept a judgment in your favor because of the terms of the judgment or the order, it seems. A court's failure to follow proper procedure results in an act in excess of its jurisdiction, such that the judgment remains valid but not voidable, and the parties may be precluded from setting it aside by waiver or estoppel. So failure to follow proper procedure results in an act in excess. So they're making a statement here. So this is a court's failure to follow proper procedure results in an act in excess of its jurisdiction such that the judgment remains valid but voidable. And the parties may be precluded from setting it aside by waiver or estoppel. So it seems like waiver or estoppel isn't the proper way to preclude an improper judgment that's voidable, if it's still valid but voidable. A final judgment or decree rendered in any civil or criminal proceeding brought by or on behalf of the United States under the antitrust laws to the effect that a defendant has violated said laws is prima facie evidence against such defendant in any action or proceeding brought by any other party against such defendant under said laws as to all matters respecting which said judgment or decree would be an estoppel as to parties thereto, between the parties thereto. However, the foregoing provision does not apply to consent judgments or decrees entered before any testimony has been taken. Jeez. All right, so we got past that part there with the estoppels. It's essentially to keep the process moving along as expected, it seems. We're on to section 28, the presumption as to validity and correctness of judgment. Now, this is going to be an important one here because presumptions seem to be what these courts run on a lot of for the most part. Just give me a second here. Check on the chat. There we go. Okay. Link to the article, please. Well, this is American Jurisprudence. There's no link. These are documents I go over here on these live streams to share with the audience. This particular one is a November 2022 update, so it's not the most recent, but the most recent I have. Yeah, so this is, again, there's no link to this, unless I guess you could get a subscription or something like that. I'm just trying to share this with everybody. So are parties supposed to be sworn in for a summary judgment? I don't believe so necessarily, unless there's testimony to be taken. But how would I know? And I guess that it depend on your jurisdiction and the rules there within their jurisdiction. Okay, so we're on to the presumption as to validity and correctness of a judgment. This one looks like it's going to be really good. Give me a second here. There we go. There we go. So I wasn't looking at all the chat. Let me bring that back up here. Yeah, this thing doesn't want to refresh. All right, there we go. Good, okay, that's where we were. Stop it. There we go. All right, now it's moving. So if you're deprived of due process law, your eviction... Well, yeah, quote unquote. It might depend on the process there, what you went through. You'd have to look at where those violations might have occurred and if it would be something voidable or would be void. Due process would make a judgment void in orders. And if you could prove a violation of due process of law, then there might be some remedy there. And you definitely have to prove it. You want some material facts as that, and you definitely want to have, you know, I mean, we're going over a lot of things here with that refer to case holdings and case decisions and such, but they're just for our guidance and to give us an indication of the way courts have been deciding lately. And this is coming from more of a perspective of American common law. But as you see, American common law has been quite corrupted over the years, and we're seeing that encroachment of corruption upon our common law with the more recent rulings by the more liberal so-called judges. Let's continue on here. So a judgment is presumed to be valid where the judgment is within the jurisdiction of the court rendering it, regardless of whether the judgment is the result of a jury or bench trial. Okay. Under such circumstances, the judgment rendered raises a presumption that the court acted honestly and in conformity to the law, and that every act of a court of competent jurisdiction shall be presumed to have been rightly done. It is presumed in support of the judgment that the proceedings were regular. It is also presumed that every requisite and every fact necessary to sustain the judgment were present. So I would ask once again here, if this is truly a fact, then you would have to see if what are the presumptions? Was everything properly done? Was every requisite, right? And every fact necessary to sustain the judgment present to deprive you of anything? That's the question you'd have to ask yourself. We're not practicing law here. We're learning law, Captain Jack. Yeah, this is your answer for practicing. Yeah, they're not practicing law, and no one's practicing law again. Yes, we are definitely learning. And let's get back to the learning here. The presumptions in favor of the regularity and validity of a judgment become stronger with the lapse of years. So, like a fine wine, the presumptions in favor of the regularity and validity of a judgment become stronger. Well, maybe not stronger with wine. Moreover, such presumptions prevail not only in a direct attack upon judgment, but also whenever a judgment is involved in the trial of another case. So when you refer, important things here, the presumption of a judgment is that every element of the case, the facts, were regular and correct and honest and in conformity to law. So when you refer to a judgment in the trial of another case, there's that presumption prevail, not only in a direct attack, but also in those other trials. And with time, it only becomes stronger, the validity. Interesting here. In a collateral attack on a judgment, the judgment under attack is presumed valid. And every reasonable presumption to uphold the judgment will be indulged. So again, to keep the integrity of the courts, we have these presumptions that if due process, all these things are followed as they should be, and every opportunity by both parties to exercise their rights to object to any errors and such, and note any errors of or lack of personal jurisdiction, subject matter jurisdiction, or authority of the court otherwise, it's supposed to be presumed to be valid and correct and honest and in conformity with the law, most important, not just process. So, in an ideal world, although challenges to subject matter jurisdiction may be raised at any time, final judgments are presumptively valid, and collateral attacks on their validity are disfavored. So, yeah, although subject matter can be raised at any time, it's best not to wait. A void judgment is supported by no presumptions. It may be impeached in any action, direct or collateral. And as a conclusiveness of presumptions regarding judgments, see section 29. And that brings us to section 29, the conclusiveness of presumptions regarding judgments. So the conclusiveness of these presumptions regarding judgments. So we're not just presuming, we're conclusively presuming. And before we conclusively presume there, let's check the chat once again. Okay, so Katie says here, I think they can only do that if they're moving back into their, yeah, everything's going to vary. These cases could be very complicated. So, yeah, it's not the case. I think we always have a remedy if there has been some wrong done. And of course, sometimes you're better than you think. And some of these things, remember, whenever you're coming in doing it alone, they have to give you certain remedial favors based on that, including the language, the timeliness of filings, and such. And not just legal aid, but also there should be certain affordances by the court themselves to understand and to assist in that, because otherwise, there's ADA violations that they would be liable of, allegedly. And yeah, it sucks a lot. Yeah, your budsman might find you something. All right, let's move along. So we're on to the conclusiveness of presumptions regarding judgments. In some situations, conclusive effect is accorded presumptions of jurisdiction to render. Wait a second. In some situations, Conclusive effect is accorded presumptions of jurisdiction to render the judgment and of its correctness and validity. So conclusive effect is accorded presumptions of jurisdiction to render the judgment. Presumptions of jurisdiction to render the judgment. Conclusive effect is accorded presumptions of jurisdiction to render judgment and of its correctness and validity. Wow, that's interesting here. Of jurisdiction to render a judgment. As a general rule, a judgment that is regular on its face and that includes subject matter and personal jurisdiction is conclusive on collateral attack. In other situations, the presumptions of jurisdiction and regularity are rebuttable rather than conclusive. That sounds more correct. As the existence of every fact essential for a court to have rendered a valid judgment is presumed, the burden is on the party contesting the judgment to overcome the presumption by affirmative proof to the contrary. Okay. So you can't just say that there's a lack of something. You have to give affirmative proof. This is interesting. Some situations, conclusive effect is accorded presumptions of jurisdiction. But in other ones, presumption of jurisdiction and regularity are rebuttable rather than conclusive. So it depends on the situation. So let's see here. Some situations, number 1 and 2 and 3. 49, 37, 35. Wow. In other situations, 5, 6, and 7 are 65, 2011, 63. The party collaterally attacking a judgment bears the burden of demonstrating that the judgment under attack is void. So again, the presumptions for the courts acting honestly and in accordance with law have a certain presumption attached, or conclusiveness to them, of that presumption. But that could vary in situations. And without further details, you'd have to look into these cases to find out. And that takes us on to Section 30. The presumption of jurisdictional facts supporting validity of judgment. So presumption of jurisdictional facts. This should be interesting. Yeah, you're not going to find good aid like that. There's assistance out there. You need to look into assistance, but you're not going to find it through regular means, because regular means are part of the regular grind of the mill, so to speak. At least that's what I've seemed to have found, and that's what's kind of pushed me into the interest of learning more about our common law. Let's continue here. So this is about our presumption of jurisdictional facts supporting your validity of judgment. There's a presumption that the rendition of a judgment is within the jurisdiction of the court rendering it. So that's the presumption that the rendition of a judgment is within the jurisdiction of the court rendering it. The rendition is within the jurisdiction. Under this rule, a judgment is supported not only by a presumption that the court had subject matter jurisdiction, but by a presumption that the court had jurisdiction of the parties as well, and that it regularly acquired and lawfully exercised its jurisdiction. Every presumption favors jurisdiction of the court and regularity of its processes. So, again, having a valid judgment has a presumption also of jurisdictional facts. Where facts were required to be proved to confer jurisdiction, it may be presumed that such facts were duly proved. On the other hand, there is authority for the rule that the existence of a jurisdictional fact or its determination will not be presumed simply from the exercise of jurisdiction. That's number 7. 1937, so that's a good old case. American Law Review. All right. That's a fast section there and very succinct. We're on to section 31, the presumption of validity of judgment and character of court, general or limited jurisdiction. Let's check onto the chat really quick on this one and make sure we're all up to date. Here, got to refresh that. There we go. Oh boy. There we go. So councilmen have helped you in the past. That's nice. In small claims court, you would probably have to get them for redress your grievances, your violation of due process, and you'd have to get them in their various capacities, it seems, if you wanted to do it for a small claims. And of course, that small claims would be with a valid judgment from that would be usable as evidence. Remember, it has that presumption of all the facts within the case being true and valid and presumed. And what was the other word they used here? Presumption and conclusiveness of the presumptions. Yeah, so that would give you a conclusiveness of presumptions from that judgment. That could be used in later cases, it seems. And that's what at least I'm picking up out of this reading here. So that's pretty interesting. Yeah, if you have anyone you can trust, it's always good talking to people. At least bounce ideas off people. Having this foundational knowledge, though, is essential. So let's continue about the presumption of validity of judgment and character of court, general or limited jurisdiction. The general presumption in favor of jurisdiction applies to judgments rendered by superior courts of general jurisdiction acting within the ordinary scope of that jurisdiction. Thus, every presumption consistent with the record is indulged in favor of the jurisdiction of courts of general jurisdiction whose judgments cannot be questioned when attacked collaterally, unless lack of jurisdiction appears affirmatively on the face of the judgment, or in a judgment roll or record, or is made to appear in some other permissible manner. A different rule prevails as to courts of limited powers in special or inferior jurisdiction, and there is no presumption that a judgment rendered by such a court is within its jurisdiction. However, where jurisdiction of a court having limited jurisdiction is shown to have attached, its subsequent proceedings have been presumed to be as regular as those of a court of general jurisdiction. So, where judgments are rendered in proceedings by courts of general jurisdiction by virtue of special authority vested in them, jurisdictions must be shown or affirmatively appear on the record. So there's no presumption here when it's in those special jurisdictions, it seems. Courts of general jurisdiction are presumed to have subject matter jurisdiction, but there is no such presumption about courts of limited jurisdiction. So there it is, summed up. And that case was 1989, Indiana, in Elkhart, County of Elkhart. All right, we're on to section 32, which is the effect of contested adjudication on presumption of jurisdiction for judgment. Effect of contested adjudication on presumption of jurisdiction for judgment. A prior adjudication on the question of jurisdiction is conclusive as to that issue, whether it is the jurisdiction of the subject matter or of the parties. Under this rule, if a court is competent to decide whether the facts in any given proceeding confer jurisdiction, and it decides that facts conferring jurisdiction are present, its unreversed and unvacated judgment, entered within the scope of the subject matter over which its authority extends, is supported by a conclusive presumption of jurisdiction. Now, remember, you get all these parts down, boy, it sounds like a pretty tight case. So that's your punch list there to ensure that that rule is followed, right? The court's competent to decide the facts and decides the fact conferring jurisdiction are present, right? Decide whether facts will confer jurisdiction and the facts are present. Judgments unreversed and unvacated. It was entered within the scope of the subject matter over which its authority. The court had authority over this subject matter. It is supported by a conclusive presumption of jurisdiction, although not without exceptions, in that the doctrines of federal preemption or sovereign immunity may control in some context. This rule of finality of jurisdictional determination is fully applicable to cases involving real property. So, again, we're back to the presumptions. If you want to win in these things, you need to focus on these presumptions because this is what's going to eventually rear its ugly head. Although not without exceptions, which most of your councilmen and other people probably aren't going to tell you about. That is your due diligence to find these. In that the doctrines of federal preemption or sovereign immunity may control in some contexts. The rule of finality of a jurisdictional determination is fully applicable to cases involving real property. Very specific definition. That's number 3. 1963, Durfee versus Duke. So, important things to consider here under the effect of contested adjudication on presumption of jurisdiction for judgment. Again, we're looking at the finality of a case, right? And there are exceptions that will allow you to have a preemption over these things. But that would be for further reading, as we'll cover that in this text here. We're on to section 33, the effect of record. Record. Again, everything you say must be made sure to appear on the record. Let the record reflect. Let the record state that. On presumption of validity of judgment. Effect of the record on presumption of validity of judgment. Records of court exercising special or limited jurisdiction. Generally, the presumption in favor of the validity of judgments prevails where the record is regular on its face. Every reasonable presumption in favor of the validity of a judgment will be indulged. Where there is nothing in the record to support allegations of irregularity. So, again, the presumption in favor of validity will be indulged where the record is regular on its face. So if everything looks good on its face without digging deep, then every reasonable presumption, reasonable, there's our word again, in favor of the validity of a judgment will be indulged. Where there is nothing in the record to support allegations of irregularity. So there's nothing in the record to support allegations of irregularity. There's no objections in the record. There's nothing to support it. There's nothing noted in the motions or anything. There's no record to support. If the defect allegedly rendering the challenged judgment void is not apparent from the face of the judgment or the record of the proceeding from which the challenged judgment emanated, it must instead be established by additional proof. The judgment is merely voidable, not void. So if they have to construct the reasoning behind why it should be rendered or challenged differently, right? It can only be voidable, not void. It has to be on its face, clear and apparent. While a judgment of court of general jurisdiction is presumed to be valid and would be held void only where its invalidity is disclosed by the face of that judgment, prima facie, on its face, or in the record of the case in which that judgment was rendered, again, is made clear in the record and apparent. No presumption exists that a judgment rendered by a court of limited powers or special or inferior jurisdiction is within its jurisdiction, and such jurisdiction must be affirmatively shown or affirmatively appear on record. The same rule applies to a judgment rendered by a court of general jurisdiction in the exercise of a special jurisdiction. So as a general rule, a judgment that is regular on its face and that indicates subject matter and personal jurisdiction is conclusive on collateral attack. All right, so as to presumption of validity of judgment in character of court, see section 31, which we did. All right, so we have here the recitals, section 34, the recitals in record pertaining to presumption of validity of judgment. All right, so this is, once again, back to our record. And before we get to this, let me just check to the chat here, because I know it's hasn't been refreshing. Let me refresh this thing here. Oh, gosh, here we go. Oh, my gosh. All right, let me catch up with chat here. All right. So just suggestion from the visionary here. Obtain open records, request the judge's bond insurance information, sue the insurance. Well, yeah, it's easily said than done, but I think the first step is to get your judgments, just like any other kind of claim that you would do with insurance or anything else. If you're in a car accident, you'd want to have clear judgment in your favor before you go to negotiate these kinds of things. So yeah, that's again, these things still apply as far as getting judgments. And then the presumptions from the judgments. Remember, these are to be indulged. The conclusiveness of the presumptions of a judgment in your favor, should you be, fortunate enough to get one. The judge was totally biased against me from. So again, denied your motion. Well, but did you get on the record? That let the record show that this judge has denied my motion for evidentiary hearing, which has deprived me of my right to due process and blah, 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 blah. If that's on the record now, on its face, that record would be a reason to invalidate. Perhaps. At the very least, have a challenge to have it voidable, right? Indeed, all public officials have to be bonded and insured. By suing their insurance or filing a bond, they'll be in trouble. They might, but again, what happens to them is not necessarily the best for you. What's best for you is getting a judgment in your favor first. I think you had a pretty good idea there before about where you could find that judgment. They're not new laws making homelessness a crime. There are some different legal theories or approaches to try to do it, but yeah. I mean, you can do anything you want. This is America, right? Could sue everybody. All right, let's get back to it. So this is back to the recitals in record. So this is what we're getting back to. The recitals in record pertain to presumption of validity of judgment. And this gets back into a denial of something like an evidentiary hearing, which is your right to have, to question evidence put onto record as to its verification and validity. The record, or recitals of a judgment, is presumed to speak the truth. If the record states what was done, it may not be presumed that something different was done. Let the record reflect that I made a motion for an evidentiary hearing and I was denied by this judge, which has denied me my right to due process. The presumption in favor of the jurisdiction of a court to render a judgment in a particular case or against a particular person prevails where there is an uncontradicted express finding in the record in regard to the presence of jurisdiction, or jurisdictional facts, where it appears by the record that the court has found affirmatively facts upon which its jurisdiction depends. Presumptions in regard to the presence of such jurisdiction are conclusive. Wow. Facts upon which its jurisdiction depends. Presumptions in regard to the presence of such jurisdiction are conclusive. So again, finding the uncontradicted express finding in a record in regard to the presence of jurisdiction or jurisdictional facts. On the other hand, there are cases in which a mere recital in the judgment record of jurisdictional facts does not import conclusive and indisputable verity. So remember, we're talking only about jurisdictional facts, not due process. In such a case, the lack of jurisdiction in the court rendering the judgment may be established by extrinsic evidence contradicting recitals of jurisdictional facts found in the record of the judgment. Furthermore, jurisdiction to render a judgment in a particular case or against particular persons may not be presumed where the record itself shows that jurisdiction has not been acquired. This rule prevails where it appears from the record that the court was without jurisdiction of either the person or the subject matter. The presumption of validity disappears when the record establishes a jurisdictional defect, where it appears from the face of the record that the court did not have the jurisdiction of the person or the subject matter. There is no conclusive presumption to preclude an inquiry into the facts. Wait a second, where it appears from the face of the record that the court did not have the jurisdiction of the person or the subject matter, there is no conclusive presumption to preclude an inquiry into the facts and to prevent a declaration of the invalidity of the judgment. It sounds like an evidentiary hearing. In fact, a record which affirmatively shows a lack of jurisdiction is conclusive as to that fact. A judgment is absolutely void if it appears on the face of the record itself, either that the court had no general jurisdiction of the subject matter, or that the judgment is wholly outside of the pleadings, and no consent thereto appears. So, again, with these, see here, cases, no more elaboration. We have recitals omitted in record pertaining to presumption of validity of judgment. The silent record. And this is going to be taking us near the end of our presentation. So let's get the silent record part down. A presumption never arises that a recital of facts in the record is incomplete. Wow. A presumption never arises that a recital of facts in the record is incomplete. So if you've left something out, there's a presumption that it wasn't left out if it's not in that record. The record's complete. Where the record is silent, all presumptions are in favor of the regularity of the judgment. That is, the presumption that the court had before it every fact necessary to sustain the judgment is not precluded by the silence of the record with respect thereto. Thus, the presumption in favor of the jurisdiction of a court of general jurisdiction to render a judgment in a particular case or against particular persons prevails, even though the record is silent as to the existence of jurisdiction, or is silent or incomplete as to jurisdictional facts. Wow, in such a case, it is presumed that all jurisdictional requirements for the entry of a valid judgment were satisfied. Now hang on a second here. The presumption never arises that a recital of facts in the record is incomplete. So it's a presumption, but you could still challenge, you would have to challenge that presumption or make clear that there is something incomplete in the record that wasn't noted, that was a fact. Wow. Okay, so another good thing to know. It's a presumption in favor of jurisdiction. Okay, yeah, all right. So we have our cases there to look for further. And nice. All right, and then that takes us to the end of this section and the end of the presentation for tonight. So I'd like to thank everybody that showed up and was able to stick around for this whole presentation. It was pretty dense. We went over a lot. So let's see here. We have from the visionary. Where'd it go? There it is. Says, I wonder how much substance the style designates one's status. I was sent a tax document where they have certain titles styled and upper lowercase explained. Yeah, it's really hard to say for sure. Yeah, Sherry, there's a lot to there's a lot more to learn, but I think you'll be able to prevail eventually as you find out more about this, and it'll elucidates a little bit more about what's been going on there, presumptions, which ones are valid, which ones aren't. It'll help empower you to take the right course of action, I believe. Katie, you're very welcome, and thank you for coming along and everyone sticking with it. This really shows yeah, thanks. Very much appreciate everyone being here along with this because it's important lessons for us all to learn and to keep alive. This dream of having a rule of right in an American jurisprudence and our common law, which is probably the best strength of this nation as long as we keep it the way it's intended to be and not let it get corrupted by these, as you see, some of the more current cases and the more corrupt ruling judges have been corrupting it to actually turn it into one of the weaker features of our nation. So let's keep this alive. For not just for us, but also for posterity. For this is a great system that you won't find anywhere else in the world that recognizes due process in such an important and significant way, which is really the foundation of making it happen. What's coming up next? We got one more episode on judgments, believe it or not, because there's all kinds of judgments. There's summary judgment, default judgments, and we want to know. Now we've gone over what qualifies a judgment to be valid or not. Now we need to go over all the different kinds of judgments there are so we can have a full understanding and comprehension of judgments, how they apply, and how we can use it all to our favor or our benefit to ensure that the due process of law is followed and the rule of right. Again, the quality being prudent, cautious. We need to exercise prudence in important manners like law or of right. So thanks again, Captain Jack. Please hit the like, everyone. And just double check on the chat here. Peace and love to you all. We don't stop. We got a lot more to go. American jurisprudence is quite an extensive library. So on that note, thank you all for coming. Salute to you all for learning this and continuing on the journey. And we'll see you on the next one. Peace out.